Well, let's get a legal mind on this now. And joining us is Nthabiseng Dubazana of Dubazana Attorneys. Good evening to you and welcome. So this was deemed to be an extradition without due process, not a deportation. To share with our viewers what this means.
So in essence, what the judge is saying here is that the process of extradition was not followed, in the sense that when we deal with international law, there's a certain process that you need to follow when you're trying to extradite somebody and bring them back into the country. Now, when you look at what international law deems to be extradition, it's an application to the court that has the person who's being prosecuted, and then informing them that we request your assistance as the host nation who has this person in custody, or in your premises rather, to please allow us to come and get them, for this person to come and face their charges within our country as they left our country or the country where the crime was committed under dubious circumstances. Now, after all of that has been done in terms of an application for a warrant for the accused person to be arrested in that country where they currently are being found or detained, thereafter, then that magistrate in that country issues an order wherein that order will be used as grounds to allow the accused person to be removed from the country, in this particular one in Tanzania, to be brought back to South Africa. And then that would be the due process, basically, that would be followed in a normal extradition. But in this situation, Tanzania had already declared Dr. Magudumana and Nthabiseng as people that are not permitted to be within the bounds of the country, and they were given 3 days to exit the country in whichever form that they could, and they were not about to flip the bill for the accused persons to leave their grounds. And therefore, that's when South Africa got involved, and then the accused persons were then handed over to South Africa. So that's why the judge is saying it's an extradition under the umbrella of a deportation.
How much does it give her in terms of pursuing an appeal? And the signal is that they would draft papers to this effect.
Well, listening to the way in which the judge dealt with this matter, I don't think it would be a good idea to pursue the avenue of appeal, based on the fact that, one, the test for urgency was already failed. Remember, this was an urgent application first and foremost. Before we deal with the merits of the matter and anything else that followed, we are dealing with an urgent application. The judge made the choice to forego the issue of striking the matter off the roll for lack of urgency, and decided to deal with the merits because he believed it was within the interest of justice for the merits of the matter to be dealt with. So if they were to go on to appeal, the issue of urgency was going to make their matter fall flat on their face. That's the first thing. So now when we move to the interest of justice, which is the merits of the case, the judge quite rightly noted that when the accused person or the applicant in this matter consented to her being removed from Tanzania, it therefore lost the protection of international law, wherein she would have been forcefully removed from Tanzania. And therefore, all these allegations and rights she's trying to claim in this application would have been something that she can fight for and would have protected her. But by virtue of consenting, all of those fell away. And as a result, South African law could now take over, which means it was like a willing handing over of herself to South African SAPS in order for her to face the charges that she's currently facing in the criminal court.
Is there a retrospective action, saying that I didn't understand that these, these were things that could have been at my disposal before I agreed to come to South Africa, that I wasn't properly advised of my rights? Is there that possibility in law now?
No, and I'm saying this based on what the judgment also said. She said that she had legal counsel in Tanzania anyway. So which means that whilst she was there, she had somebody who has legal knowledge who could advise her on what her rights were at the time while she was in Tanzania. Upon her being handed over to South Africa, she acquired legal counsel as well, who had the opportunity to advise her on this also. The problem is that when she appointed the current legal team that she has, she forwent all the information that she probably had when she was in Tanzania and after she landed in South Africa on the 13th of April, if I'm not mistaken. And then she went on to a third legal representative. So she cannot claim ignorance of the law. Unfortunately, or fortunately, depending how you look at it, ignorance of the law is not a defense in our country.
So the judge said that she ought to challenge her deportation in Tanzania. That's part of what you dealt with there, because our courts have no jurisdiction. How would she need to do this inside of a possible appeal?
Well, she would have to basically start the matter from scratch in Tanzania, because it didn't start there. In other words, the urgent application that she dealt with today was never dealt with in Tanzania. So what would need to happen is that however the civil court in Tanzania works, she would have to take it up there. And then whatever ruling that she gets in the civil court of Tanzania, if they have a system like ours, I really don't know what their system is like, but if they have a system where there's civil court and criminal court like ours, then after whatever claims that she would have, she has won in the Tanzanian court, and they confirm that her arrest was therefore unlawful and all of that, that ruling she could then use it as a basis for a new application within the bounds of South Africa. However, if it's going to be in an appeal basis, she can't use it. And this is the reason why. When you make an appeal, you're not using new information to say, listen, by the way, in my original application, I forgot to mention this. This is why even in today's ruling, the judge was saying that in the answering affidavit, there were too many new aspects that were being dealt with. And he struck all of those things from the roll, from the matter, I beg your pardon. And therefore, they cannot be dealt with. So she cannot come with that new information in appeal. She has to deal with what she decided to deal with in her founding papers, and that's it.
And there's a lot of money at stake as well. Various projections around how much this is already costing go north of 200 to 300,000. So it's not a cheap process. Thank you very much for talking to us tonight. Nthabiseng Dubazana of Dubazana Attorneys.